Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, February 27th, 2025 at 7:01 in the morning. So we're back to continue our discussions on H342. We have with us a friend from the AG's office. Todd, if you'd like to join us.
Morning. Todd Delos from the Attorney General's office. So I have, I think, one of the later drafts, but I don't think I have the latest draft. But I wanted to start with just a couple preliminary comments and then open it up because I think there are a number of questions that members of the committee have, and I'm happy to answer those. Actually, I want to grab one other thing. I like books. And I know Rep. Cooper's not here, but he had some questions about Title IX and the expansion of if there were any expansion of authority by that cross-reference to Chapter 63. So I'm happy to talk about that as well. First and foremost, just a note of appreciation for this committee's work in the data privacy space. It's a complex, fast-moving, and extremely important topic. I know that the Attorney General was here maybe 10 days ago to talk about this, and I just want to reiterate, or was it last week? Just reiterate the appreciation for your work. On 342, likely on S71 when it comes over, S69, which is already here. Broadly speaking, the Attorney General supports the goals of S342, and we are comfortable with draft 2.2 that Ledge Counsel walked through this morning in terms of the grant of authority to the Attorney General's office, recognizing there are a lot of policy decisions for the committee to make. We continue to support a private right of action in this and other data protection spaces. We think it is really important that individuals are able to vindicate their own rights and ensure that if there are violations that impact their privacy, that they can go forward as they have been able to do since the advent of the common law to vindicate the harms against them. So I would say that broadly to the questions around AG authority under the new section of, I think it is C1B. It's fairly standard language. This is on page 7 of draft 2.2. This is fairly standard language in terms of our authority to adopt rules and otherwise carry out investigations. It largely tracks the language in the Consumer Protection Act, which is Chapter 63 of Title IX. And to questions about whether we should call it fines or civil penalties, as Ledge Counsel walked through, civil penalties is the language in the statute. It's the language we use at the AG's office. And most of the other authority you'll see in there is our ability to investigate, our ability to demand information, our ability to file suit, and our ability to seek remedies. By and large, that is what is referred to within the section of C1B. Maybe I'll stop there. The one other thing I would say is we do feel there's a real importance to enabling dual prosecution. If the committee were to take the draft as provided this morning that allows an individual to follow track or the AG to follow track, we would just want to be sure that the AG's authority is not circumscribed by an individual's choice and application of the law, by which I would mean if an individual filed notice with the AG, again, taking the draft as it was provided, filed an action against data broker bad guy. If the AG received a bunch of complaints, we would not want to be foreclosed from also going after that data broker simply because there was a private action already in play. That is currently the case under the law. We just want to make sure that that dual prosecutorial track, the AG's authority, namely, is not circumscribed by the law. I'll pause there. I'm getting quizzical looks, so maybe I'll back up.
My initial concern that I wanted to ask about, maybe just what we've hit the nail on, are we looking at a double jeopardy situation here because of the dual tracks?
I think what we would be looking at, I will say, part of the reason we support a private right of action in a lot of these spaces is if the Attorney General is the entity responsible for enforcing this kind of law, then the taxpayers are going to pay for individuals' rights to be vindicated. When we file a lawsuit, whether it's against a big company, a small violator, we file on behalf of the people of the state of Vermont. And so it is technically a different action, and we are looking at usually patterns and practices. So it's rarely an individual case from an individual. It is much more often we see a certain number of complaints or a certain measure of harm, and that's when we step in on behalf of the state and the citizens of the state to act.
I guess I need a little help with reconciliation, because when we first looked at this bill before this amendment, I specifically heard the Attorney General say that this isn't something they wanted to mess with. But now we have the private right of action in, and now it's okay for you to mess with it. So, right, help me reconcile that in my mind.
Sure. Help me understand. I'm happy to answer it. When you say mess with,
What I'm saying is we asked, because when we originally looked at this, one of the things we're looking at is just having the Attorney General deal with it.
Mhm.
And the Attorney General said they didn't think it was a good fit. Now that in lieu of a private right of action, now that we've put the private right of action in, now it's a good fit for the Attorney General. And I'm having a real hard time understanding what changed.
well, I think when it's a little bit how I responded to Rep Bosch's question. Am I pronouncing that right?
Perfect. Thank you.
When we file an action, when the AGO acts, it is on behalf of the people of the state of Vermont. It is not one individual's lawsuit that the state is taking on that individual's behalf, right? So what we are attempting to do when we file an action, be it against a major, I'm just trying to think of a recent one that's publicized. There was a data breach several years ago with a company called Blackbaud. I think we've talked about that here before. We filed on behalf of Vermonters in order to protect Vermonters' general rights under that. An individual may have also had a right to say their data was breached in a way that violated the law, and they can show damages. So we want to make sure we're not foreclosing that personal ability to file a private right of action. And as long as both are kept, we are comfortable with our authority being expressed as it is in this version. So what changed is, as long as we're seeing that path, and there may be other avenues too that aren't in this bill, but for what's in front of us, as long as there's that path for an individual right of action, we're comfortable having dual authority.
Okay.
Yeah, so currently the right to sue is across the board. The difference in this bill is that we're doing liquidated damages. Correct?
The statutory damages on this is under C2.
Right.
Yeah.
So what we're looking at as we've got the liquidated damages, which allows a company to come in and do that. And then on top of that, we would be suggesting that the AG could also do it as well, sue under the current. It is kind of double dipping, for lack of a better term, correct?
I'm not sure I totally follow, but let me try and go back to
Hard
you.
to follow me.
It's 11:10. I don't know. So the scenario you're playing out would be a third party sues on my behalf because my data is being shared by a data broker. And then the AG chooses to take an action as well to say this is contrary to the interests of the state of Vermont, and therefore they're suing. It is possible. I think this is where there are two levels of discretion, and I understand why legislative committees don't love it when people are like, we aren't going to do it that way. But there's the prosecutorial discretion of limited resources and how we expend those. And if we're really trying to realize the rights of Vermonters and it's happening independently, it's not a space that I believe the Attorney General is going to step into unless there's real willful and wanton violation that has a public policy concern to it. The second point is, and I wouldn't want to opine on how a court would look at it necessarily, but there is a question of what are the damages if they're being paid out in one column to the individuals, how much is really going to get paid out to the state otherwise. None of that is definitive, but that's how I would look at that question.
Yeah, Todd. So this basically mimics the structure, I think, of the consumer protection fraud kind of statute of having the AG having some authority where there's a statewide interest of some sort, but also the individual being able to take matters, and file themselves. How does that, do you ever, and I think I'm hearing some concern that, there might be conflict or whatever, or dual double jeopardy, right? How does that play out in the consumer protection field? Do things like that happen, or does, like you say, the limited resources of the Attorney General sort of constrain you if something's already been taking place?
Yeah. Thank you for the question, Rep. Olson. I'm not aware of it happening. It's certainly not something that I think comes up with regularity in our consumer work. It is much more frequent where we will act where there is a significant harm across the board to Vermonters. And again, the Blackbaud case, and we worked very well with them. I don't want to malign that company at all. It was an unfortunate incident, and it worked out as best I think it could. That was a circumstance where I think it would have been tricky for individuals to really understand and vindicate their rights, whereas there was a clear state interest in that case, namely the breadth of harm done, and therefore the Attorney General was able to act more appropriately. And it is that there are circumstances, well, I'll leave it at that.
Thanks. One, I just want to say it was great to see national press around AG Clark speaking at the Bar Association conference this week. Really excited to have her as a champion in New England. So, Todd, for this, we're really the dual track here is that the AG is not going to represent an individual generally, it's going to be a class action. And the worst most horrible cases that, it makes sense to take on as a group. So these dual tracks, just to clarify, gives the individual the ability when the AG won't represent them, but it is critical to have both options here, just similar to other privacy mechanisms. Is that?
Yeah, I would agree. The one small tweak I would make, Rep. Priestley, is I wouldn't consider what we do a class action, because even a class action is an individual representation model. But
yes, great, thank you.
Questions? Additional question around this language in the bill that talks about assessing a central penalty of 10,000. So how would you construe that in terms of either, the mechanism for assessment and where it goes, where the civil penalty would end up?
So that's consistent with the rest of our consumer protection work, and recognizing this isn't strictly a consumer protection bill. This seems to trend towards privacy. And I think the linkage over to the CPA, the Consumer Protection Act, is much more a creature of statutory clarity, in that that's an act that provides the scope of our enforcement authority. And so bringing it into this just makes that an easier cross-reference. In answer to your question, we generally work within that $10,000 per violation framework as a means of assessing, that becomes the ceiling, and then you work down from there based on attempts to mitigate, ability to pay. There are lots of those kinds of considerations that are very case specific, very fact specific, and it depends on the actor, the engagement in the investigatory phase, and the nature of the harm and scope. Those are just a few of the criteria we look at.
And where would the penalty be defined?
I don't want to get too far out on a branch that is thin, for the record, indicating my own lack of deep knowledge here. But essentially what happens is all of those penalties get paid into a fund. And when you pass the budget, there is a certain amount that the AG holds back, and the rest goes into the general fund. So our budget is not based on how much we bring in. We have a budgeted amount, and then all the overage goes into the general fund. And it's, I think, between $2 and $4 million a year that goes into the general.
Um, everybody. So I guess my quick question is to follow up on Herb. If there is the introduction, I mean, you mentioned that the civil penalty sort of makes it more clearly a consumer protection component. Is there a tension of this bill having both of those elements? Or is this bill, can it be construed as consumer protection without a civil penalty?
Thank you, Representative Cooper. I would say I'm not sure how it is construed broadly in a committee conversation. I'm not sure that matters based on what it's really trying to do. My point was in referencing Chapter 63 of Title IX. That cross-reference simply provides the general authority that the AG has in consumer type matters, whether this is a privacy matter or a consumer matter. It's going to sit in Title IX. I think courts can look at how that's construed. I would say to the question of whether there are civil penalties or called civil penalties or fines, I think for the purpose of consistency, we would say civil penalties make sense. That's what we call them across the board. But I don't think that's going to make a difference in terms of how the bill operates. I think it operates similar to our authority in other areas, namely consumer areas. I don't know if I answered you though.
I'm sort of trying to grasp it, I think about the rationale for the inclusion of a civil penalty, which we had not, I don't recall if we'd sort of contemplated this number prior to this draft of $10,000. And my question was whether there's any risk we're running for it being difficult to determine what we're attempting to do by attempting to do things in more than one way. And my curiosity is around how that is interpreted as a legislative act and from a legal perspective. It may not be a thing I have to worry about, and that would be great to hear.
I mean, I think I follow. The 10,000 figure is the standard figure that we use across the board in consumer protection. And again, as I was saying to Representative Olson, that sets the ceiling from which we operate, generally speaking, downward based on how an investigation and an engagement with a potential violator goes. I don't, off the top of my head, I can't think of why that would be legally concerning in this law, but I haven't given it much deep thought in terms of cross-referencing into the Consumer Protection Act or otherwise. So I don't know if I can tell you enough to say don't worry about it.
My thought was, are we consumers of this? If it feels in some ways that our data is the product, and maybe that's what I'm trying to really raise as a perhaps not irrelevant, but maybe it is irrelevant. I'm not sure.
I would say in this bill, the operative term is covered covered person versus consumer protection, which relies on the standard Chapter 63 definition of consumer. So in that sense, it is not a consumer bill because it's really focused on an individual group. Again, I think the cross-reference to the AG's consumer authority is largely a statutory drafting tool to make it clear where our authority lies and how it is circumscribed.
Thank you.
Questions? The thought of having a covered person notify you or notify the AG when through the form when when the data broker hasn't complied in a 15-day period, to send that on to you, or send that on to the AG, so it kind of gives you an idea of what's going on in that world, right? And I think that would give you the ability to decide whether or not there's an issue going on with this data broker and whether you should step in or not.
I completely agree with that. I mean, we are a complaint-driven, generally speaking, our consumer work is complaint-driven, and that would be a form of sort of clear complaints.
Yeah. Maybe you'd add that in there, Rick. It's in there. It's in there. Anything else for? Deputy Attorney General. Oh, thank you very much.
Happy to answer questions offline as well, if folks have.
Maybe I think this is the point where we stop. We have to, we have a luncheon date with the Director General from the TACO office in Boston and Taiwan Council General. And so I will ask the speaker if we can come back to the floor to try to see if we can come up this up or not. I do want to make sure that we're on the floor during the reading of the resolution. Vice Chair will introduce the Council General and Deputy. The resolution won't be read until quarters of the day. So it'll be read, we'll vote on it, but the introduction will come prior to that. So once that happens, and if we have permission from the speaker, after that, I'd like everybody to come back here. So that we can see if we can finish that. Rick, are you open this afternoon?
I have a Senate bill on the floor, but once it's third reading, but I'll just cover that. That's 71, so I need to be there for that, and then
Yep. And that's it. Do you know what time they're planning?
well, it's 1 o'clock,
Okay.
or and it should be one of the first things.
Okay, so probably that would be done by the time we get here. Michael?
Is the language gonna change from this morning? Cause I mean,
We have those two adding more pieces, being a little more prescriptive in the form.
Okay.
What else was there? Oh, we need to change on the study. We've got to take AOA out as the umbrella and put ADS in.
It's in there.
Okay.
Yeah.
Okay. At least somebody's- Okay, so we
Turning
can go,
her
we
page.
can go over that and take a look at it and see where we're at, where we are, have our discussion and go from there. And have you gotten ADS's?
I saw the email.
Yeah, so if you can incorporate their suggestions.
No matter what they are, just incorporate.
Yeah, well, we're gonna talk about it. If we don't like them, we can pull them out. Okay. Okay.